Hello, good morning, good afternoon, good evening, depending on where you're joining from. Thank you for joining our weekly live stream to discuss all things related to digital transformation. My name is Eric Kimberling. I'm the CEO of Third Stage Consulting. We're an independent consulting firm that helps clients throughout the world with their digital transformation journeys. And we're here to discuss today legal risks and digital transformations and ERP implementations. And I'll introduce our guest here in just a moment who will be helping us unpack this important topic. But first, just real quickly, before we jump in and introduce our guest, a couple of logistical things. First of all, as I mentioned, this is a weekly live stream we do every Tuesday, same time, same place. We stream to LinkedIn, Facebook, X, and TikTok as well. And so wherever you're joining from today, thank you for being here. We're watching the streams and the chat, so we encourage any questions or comments you might have along the way. So we're filming this interview live for our Transformation Ground Control podcast, which is a weekly podcast we publish each Wednesday. And once we get done with this interview, we will repackage it, we'll edit it, we'll add some additional content, and we'll release it as a digital or as a Transformation Ground Control podcast. So by being here today, you're part of that live production. So thank you for being here today. You can find that podcast at transformationgroundcontrol.com, by the way, if you want to see any of the past episodes or you want to see this episode when it does come out. Just go to transformationgroundcontrol.com and you'll find all the past episodes there. Secondly, we are going to take audience questions here today. I've got some questions to get us started, but I really want to make this about the audience and your questions that you have for our guest here today as it relates to legal aspects of digital transformation. We're going to cover everything from contracts to AI and intellectual property as it relates to AI and a bunch of other things, but anything you want to talk about as well. Would love to hear your questions and comments here. We're watching the chat. If you don't mind just dropping any questions you have along the way in the chat. And speaking of the chat, if you don't mind dropping in the chat where in the world you're joining from today, what city and country are you joining from today? We'd love to see where this global audience is joining from today. Today I'm joining from Mexico on holiday, and our guest is joining us, I believe, from Chicago. But I'd love to hear where everyone else is joining here from today. So again, our topic today, legal risks and digital transformations and ERP implementations. Joining us to discuss this topic is an attorney who's the perfect person to discuss this with us here today, Marcus Harris. Marcus, thanks for being here today.
Hey, thanks, Eric. I always enjoy talking to you about these issues. I think they're certainly timely, and really, there's been a few new developments that I think are substantive that I'm excited to share. I am a partner at a law firm called Taft, based out of their Chicago office. Got a really good view of a green river that they dyed on St. Patrick's Day, which is vibrant green.
Nice.
So I've got a good vantage point here to talk to everybody from. But yeah, thank you for having me. I'm really looking forward to the discussion, and I think it's an important topic that I think it's a difficult topic, but I think it's something that you got to address. There's risks with these things, and the goal for me in having these kinds of conversations is to really kind of cut to the quick and make it easy to understand, so that you can compartmentalize this and focus on what you need to when you're negotiating these contracts and thinking about the larger picture.
Yeah, that's great way to put it and great way to look at it. And with technology changing as exciting as it is, unfortunately, that comes with a price tag or a risk price tag that people like you can help us understand a little bit more in terms of what some of the risks are and some of the legal nuances are. So I appreciate you being here today. You've been doing this for a long time, though. Maybe tell us a little bit about your background leading up to your time here at Taft Law. I mean, you've sort of seen both sides of the table here in terms of being working in your practice here at Taft, but also being on the side of the vendors as well.
Yeah, I started my practice over 20 years ago. It started out in litigation, and then I moved into working in-house at a couple of different software companies, SAP, and then a software company, SSA Global, which was acquired by Infor. And so, I've got a good understanding based on that experience of how these software vendors operate, what concessions you can reasonably ask, what they are going to give you. I think the hardest thing about this going into these negotiations is, it's easy to see what's in the contract, right? It's easy to see what's on the paper in front of you, but what isn't there that should be there, and what should you be asking for that they're willing to give you that if you don't, you're just, you're leaving something on the table that you can obtain. And so I think, the in-house experience is valuable, and I think it really enables us to, just get down to business as far as, look, we know you're going to give us this. We don't need to posture. We don't need to push back. This is the reasonable position that everybody agrees to, and it's a more efficient way to do this, less confrontational.
Yeah. Yeah. And you and I first met in litigation, really. It was one of your litigation cases where you were involved in a lawsuit involving a dispute between an ERP vendor and a customer. And the reason I bring this up is that, you've seen the angle from upfront helping clients negotiate these contracts, but you've also seen the flip side when things don't go so well and things get into an implementation, into a dispute. You've sort of been involved in the trenches helping through that process too. Can you share a little bit about that background as well?
Yeah, that's right. And I mean, I've litigated, hundreds of ERP failures in courts and before arbitration panels across the country. And the interesting thing about them is they all follow a similar trajectory, a similar path. It's the same story over and over and over again. I can have somebody call me, they've had a $30 million ERP implementation failure, and I can basically kind of go through the steps and tell them, what has happened to them, just because it's almost formulaic in the way that these things fail, right? It's the same things that that happen almost every time, and the facts are going to be different, and there's going to be a different mix. But generally, we are going to have a good understanding of where the bodies are buried, what was said to the customer, where the failure points are. And it's just a matter of rolling up your sleeves and getting into the facts and understanding what's specific about that particular failure. But having the litigation experience with the contract negotiation experience is actually unusual in my field, and they both really make you better. I think when you're negotiating these contracts, you're able to identify provisions that are likely to be litigated, and focus on those, and the other provisions that are less likely to ever come up. I mean, you certainly address those, but you're not going to spend as much time dealing with those. And then I think on the litigation side, you're able to just go through those contracts, find the key terms and provisions, understand how those provisions are going to govern and impact the litigation pretty quickly. So it's a good solid practice. And we've been doing this a long time, really helping, in my view, customers that have been victimized by kind of big ERP, misrepresentations, minimizing complexity, and then lack of experience or abandoning projects. I mean, we see all of these things, and we really do hold these guys their feet to the fire, so to speak.
Yeah, a lot of flawed assumptions go into these contracts or SOWs oftentimes, and we'll get into a lot of that up here, I'm sure, here today. Before I jump into the first couple questions I have for you here, Marcus, just want to say hello to some audience team members here today. Darian joining from LinkedIn, our co-host. Thank you for being here today. She's our podcast co-host. Selig from Cape Town, South Africa. Thank you for being here today. Owl Hater is the name on YouTube, joining from Jacksonville, Florida, formerly from Chicago. And then Charu says, good day. So hello, thanks for joining here today. And again, wherever you're joining from today, love to hear what city and country you're joining from here. And any questions you have along the way, please drop those in the chat. And actually, as I'm getting to my first question here, I'll kind of ask this question of you, Marcus, but I'll also ask it of the audience in parallel. But I'll start with the audience. And if you don't mind just dropping in the chat, what do you see as the biggest concern or risk you have from a legal perspective as it relates to whatever initiative you might be working on, whether it's an ERP implementation or some sort of broader digital transformation? Love to hear your comments in the chat on what you think the biggest legal risk is you face, or the biggest legal concern is you have. But kind of shifting that question over to you too, Marcus, what are some of the biggest challenges that you see, just to sort of set the stage here, with all your years of negotiating ERP contracts? What are some of the biggest risks that you see organizations face?
I think you've got to look at this in a couple different ways, right? I mean, it's really, what are the risks associated with dealing with ERP vendors in general from a legal perspective? And then what are the risks associated with negotiating the ERP contracts? And I think that's a much narrower question, and that's really changed over time, and particularly over the last, I'd say, probably 3 to 5 years, we've really seen a different emphasis in the way that these guys will negotiate their agreements. And one of the prevalent things that we are seeing on a regular basis in the contracts that we're negotiating is really the presentation to the customer of what appears to be a very simple document. Okay. It will be 2 pages, it'll be 3 pages, and then there is an incorporation by reference of other documents that are found online. And you can't tell on the face of that order form or SOW, how complicated those other documents are or what the risk associated with them is. When we first started seeing this, it was very easy, at least, to identify the fact that they were incorporating by reference these documents. Okay, what they are doing now is they don't necessarily highlight that it's a URL. They'll just say, oh, and there are these other documents. Now, there's a question as to whether that's legally enforceable. Oracle just dealt with that issue in court as to the enforceability of a reference to online agreements. And so what that does is it really hides the ball. And so you're signing what looks to be a 2 to 3 page contract that's very easy to understand. It lays out all the the dollars and cents and the products. But what you have signed up for, you have actually no idea, because you haven't even really looked at it, right? And no one has taken the time to negotiate it. So, you signed form contracts that are going to be one-sided, unreasonable. They're going to not provide you with any substantive relief in the event that there's a problem, and you didn't even know you did that. And I think that's a huge risk. And they make it seem easy, and you may not even know that those agreements exist. And now you're in a whole world of hurt if something goes sideways. So I think that's something that people just need to be aware of, is to really put the amount of due diligence in these agreements that's warranted. And we see this all the time. You would think, okay, well, it's a $50,000 software transaction where that happens. No, they're $50 million software transactions. They're 60, 70, $80 million is being spent without adequate contract review. And I think that's absolutely malpractice on the part of that company. Some of the other things that we'll see in the agreement specifically are warranty obligations that are hollow. We like to say that a software warranty or a performance warranty with respect to services is really a warranty of time and a warranty of reference. And so what we'll see is some sort of a warranty obligation with respect to that software, but it only lasts for 60 days after the delivery of that software. And what constitutes delivery is not what you think, right? It's the date that you sign the contract. Maybe there's some sort of a download where you get some base code, and you've got a warranty for 30, 60, 90 days, but it's going to take you 2 years to do the full implementation of that software. And now you have nothing. If something goes wrong, you don't have a framework for addressing whatever that issue is contractually. What you're left with is having to sue them in court, which doesn't make any sense, right? I mean, it just doesn't work. We also see broad, I would say, exceptions to these contractual obligations. So sure, we will indemnify you as a vendor, or we will provide you with this substantive warranty where we're going to agree to provide services in accordance with generally accepted industry standards, highest industry standards, professional, whatever it is, or we warrant that the software is going to comply with the documentation. But what they'll put in the agreement is, well, we will do all those things. We'll provide you with a robust indemnity warranty for intellectual property infringement and just a warranty in general, but not if you use it with a third-party product that we don't provide to you, which is ridiculous, right? I mean, you can't.
Right.
That's the way the world works today.
Yeah.
They won't provide you with any of these obligations if you use the product in a way that's inconsistent with the agreement. Who knows what that means? That's open to interpretation. So it's really getting into the nuts and bolts of these things, where I think if you're going to summarize it, it's where the vendor doesn't really have any substantive obligations. It looks like they do, but it's all open to their subjective determination as to whether they want to actually do anything or not, and the contract provides them with that out. And that's just not that's an incredible risk when you're dealing with these types of agreements. You've got to have these agreements reviewed, you've got to have them revised, negotiated, and there has to be real substantive contractual obligations on the part of the vendor if you're going to have relief.
Right. Yes, because sort of these one-sided nature of these contracts. And that sort of leads to a couple comments from the audience here. And, I asked the question, what are your biggest concerns or risks as it relates to the legality of these projects? Eamon on YouTube says how to build the knowledge needed to review the contracts is one of the biggest concerns he has.
Right.
Sharu has a concern with data moving to the cloud. Most ERPs are on cloud platforms these days. Let's talk about that for a second. Data in the cloud. What does that mean from a legal perspective in terms of cybersecurity risk? Who actually owns the data? What happens if the data is breached? What are your thoughts around data? I know that's a big can of worms.
It's a huge can of worms, right? But I think the risk is real in that the liability associated with doing it incorrectly or having a data security incident or a data breach, whatever you want to call it, there's massive liability associated with that. I mean, if you look at Target, I think Target was $120 million worth of liability for the data security incident they had that I believe was related to an ERP implementation or software implementation. You look at Sony, I think they were around $60 to $80 million in liability. So, these things are real and they're going to be a tremendous pain point. And so how do you mitigate that risk? And I think it's really more of a three-pronged approach. First of all, you have to have representations and warranties in these agreements that are real, like we just talked about, where that software vendor is going to step up to the plate and tell you that they are implementing industry standard security protocols. There's an ability for you to audit those practices once a year, twice a year, whatever it is. They are going to have some obligation not to introduce viruses, code that is going to be problematic. And then you've got to look at the disclaimers of liability associated with those. Data loss is something that used to be typically disclaimed, but in the context of data security, it's not really reasonable anymore, and you've got to massage that type of language. You also want to make sure that you've got a data processing agreement in place that obligates them to comply with applicable data security laws wherever they're located, right? I mean, typically it's going to be something like GDPR or the California law or whatever geographic scope that you're dealing with. You want to make sure that those are all addressed in the agreement. You want to make sure that you're only disclosing enough information to that vendor that is required for them to actually do the job. And if they're going to get it, what are they going to do with it? Is it going to be anonymized? How are they going to utilize it? Are they going to train large language models with it? Is there going to be an AI implication? I mean, there's a lot of issues here to unpack, but I think you've got to make sure that there are concrete obligations around data security for the vendor, and you've got to have an understanding of what they're going to do with it. And there's got to be a process for dealing with some sort of data security incident if it should occur. And you also want to make sure that with respect to limitations of liability in the agreement, that they're not so low that you don't have any recourse. Usually you'll have, some flavor of a cap on the direct damages that's tied to the amount of money paid in the last 24, 12 months per SOW per agreement. And then you have to have carve outs or a super cap for some of these other things, data security being one of them, because, like I said, you're looking at $120 million in liability. And if you cap the amount of you can recover from that vendor at the amount of money that you've paid in SOW, probably not going to help you very much.
Right. Yeah. Yeah. Now, when you mentioned the training the AI models, I want to come back to a question that the audience has here too in just a second. But before jumping to that question, just a real more basic fundamental question. If I'm an ERP customer and I'm buying ERP software, most of these vendors now are building AI into the tool set. Do I have to give permission for them to use my data to train their AI models, or how does that work?
You do, and there's going to be some sort of a provision in those ERP contracts that's going to grant that vendor the right to utilize your customer data in a way that allows them to provide the services. And you have to, there's nuance there, and there's some, fancy footwork that you've got to do to make sure that all aligns. But to answer your question simply, yes, there needs to be some sort of right to access, right to use from you as the customer to that data, so that they can do something with it in connection with that contract. They're also typically going to require that there be some sort of a rep and warranty that you own that data or have the right to it. And if you don't, there's going to be some sort of indemnity obligation associated with it from you to them, which is probably going to be overly broad, unreasonable, and as expansive as you can imagine, wherein, as their indemnity obligation to you is going to be incredibly narrow and ineffective.
Right. Now, what about this? Speaking of AI, here's another question. This is a great question from Darian on LinkedIn. She says, with the rise of AI-driven ERP solutions, do you see vendors shifting even more liability onto customers for AI-related errors or misinterpretations? So AI, in other words, has a delusion, it's delusion, delusions in it or whatever, or misinterpretation of data. Is that risk you, the customer, or is that risk the vendors, or both, or how do you view that?
Well, I mean, I think in the ideal world, as a customer, you're going to want to put most of that risk on a vendor, and from the vendor's perspective, they're going to want to put most of that risk on you, right? And so there's got to be a middle ground where there's a reasonable allocation of the risk that is associated with faulty performance of that AI model. And usually, the contractual framework that we use for software in general is going to be the model that you're going to use to address it. But certainly there's going to be a reluctance on the part of that vendor to have much responsibility for the outputs, right? And they're going to try to put as much responsibility on you for how you're using that AI functionality. Certainly, you need to be responsible for the outputs that are being generated. There's going to be issues around indemnification, especially from an intellectual property standpoint. And this is a very valid issue that comes up pretty frequently right now, is how do you obligate that vendor to represent that they own the data that is being used to train that large language model, especially if it's an open model and they're just getting it off the internet. There's got to be some sort of a representation that they've got at least a right to utilize that. But good luck trying to get them to indemnify you for infringement. It's going to be challenging. We've got certain strategies that we've developed over the last couple of years that we're utilizing with particularly AI vendors, and certainly with ERP providers that incorporate AI functionality into their contracts. But it's a minefield right now of legal liability and negotiating these contracts to try to be reasonable. And I think the larger AI providers that we've dealt with are pretty balanced and reasonable with the way they address these issues.
Yeah.
And I'd say it's the ERP providers that are difficult.
I'm sorry, say that again. It's the ERP providers.
The ERP providers that are incorporating AI functionality into their product, they're a little bit more difficult to deal with.
Yeah.
Say something like OpenAI is generally pretty reasonable in negotiating their contract, where somebody like SAP is, seems like they're consistently trying to hide the ball, and they've got language in there that allows them to modify the contract at their discretion unilaterally to address changes in AI functionality going forward. And it's hard to beat that back sometimes.
Yeah, that makes total sense. I want to say hello to Sandra, who's joining us here from Chicago. Thanks for being here, Sandra. So along those lines, then, what about You said the ERP vendor is a little more difficult to deal with than, say, an OpenAI or some of the AI specific vendors out there. What about not just in terms of contract negotiation, but also in terms of data ownership or intellectual property, I should say. And let me try to phrase this in a layman term sort of way. But when I've got data within my organization and I'm using it within an AI model, let's just say I've given permission to the vendor to use my data to train its AI model and whatever results I get back from it. Do I still own that data? Have I given up some sort of ownership of that data, or how does that work? Because I've read recently how you can't get a copyright on something that AI helps you write, and so there's intellectual property issues there. But what about if it's already my data? It starts off as my data, but then I use it to feed an AI model. Do I cede any sort of control or ownership of that data and intellectual property?
You very well might. And the problem with that is, if there's no transparency in this open system versus a closed system that's where the large language model, for example, is utilizing your own data to train that model, that's a different story. In the context of an open AI model, where your data is being mixed in with hundreds of others or thousands of other customers, and the data that's coming out, what is the ownership interest in that data? That's a very good question. And you're absolutely right, Eric, when you say that information is not copyrightable. And there's some nuance to that. I mean, if there's substantive human involvement, I'm speaking generally right now, then certainly you could get, the case law suggests you certainly can get some sort of copyright on that if there's human intervention, human involvement with the output at some point. But if it's simply, machine generated output, if you can't even get a copyright ownership interest in it, what's the ownership associated with the output in general? I mean, certainly you own, or you should, and the contract should address that you own the underlying data, right? But what the ownership structure associated with the output is not always clear. And I think when you're negotiating these contracts, you need to make it clear. And it's going to be dependent on the type of large language model, the type of AI functionality that you're dealing with, and what it does specifically. So, it's not an easy question to answer, actually.
Yeah, I was hoping for that easy answer, that one size fits all answer.
Well, yeah, consultants and lawyers like to say it depends, right? And there's unfortunately some validity to that.
Yeah, I know. I keep asking you some of these questions I'm framing it different ways, wording it a little bit differently, hoping I get that easy answer. But it usually comes down to it depends.
Yeah.
After all these years of knowing you, I should know that that's the answer we're going to get. But it is true. I mean, it just goes to show, though, how much this stuff changes, and with technology changing as fast as it is, that means the legal implications are changing quickly too, in terms of some of the stuff you've got to look for in contracts and whatnot. How do you see, do you see any sort of material impact of AI on, let's just say, the success or failure or risk level of these sorts of implementations? Have you seen enough data? Are we far enough into the journey to know yet how AI is going to affect the legal, or not the legal aspect, but just the risk level of these projects?
Well, I think that's a really interesting question. You can deal with that question in a couple of different ways. And one is the utilization by the implementation team of artificial intelligence tools or functionality to help them implement, integrate, customize, and modify that ERP system. And I think there's a tremendous amount of risk associated with that, because who knows what they're utilizing, what kind of rights they have in that functionality. Are they going online and basically copying code? And again, what's the ownership interest in that code, and is it infringing if you can't even get a copyright in it? I mean, these are nuanced, roundabout kind of questions that are incredibly interesting, certainly to lawyers. But yeah, I mean, I think the utilization of artificial intelligence in the implementation process itself, I think, creates substantive risk. And you've got to address that, with the warranties and representations and limitations of liability and indemnity provisions that you put in those consulting agreements, those MSAs, and to make sure that you've got meaningful relief if something happens, whether it's just a standard contractual breach or it's a breach associated with the use of artificial intelligence. The other way to answer that question is, what risk does the incorporation and utilization of artificial intelligence into the ERP product by the customer, or the use of it by the customer, what risks does that carry? And I think it carries a tremendous amount of risk, depending on what the nature of that functionality is exactly and how you're using it, right? If you're using it in connection with making decisions about hiring or firing, that's going to present a certain type of risk that's going to be different if you're using it to automate the process of the review and processing of invoices or something, right? So the use case is going to dictate the risk, but there's a tremendous amount of risk associated with it. You've got to look to things like, are we going to accidentally disclose trade secrets? Are we going to be incorporating confidential and proprietary information into the AI model? The copyright infringement, something that you referenced a second ago. What kind of algorithmic bias are we being subjected to because of the AI model?
Yeah.
And I think having an understanding of the transparency associated with the algorithm, depending on what you're utilizing it for, is going to be important, and putting that kind of language in the contract so that you understand what you're getting yourself into and where the risks are, so that you can mitigate those risks within the body of that contract, is going to make a lot of sense.
Yeah. That's super interesting. And I also wonder, I suppose this isn't so much a legal angle as it is just more of a business competitive angle, but I do wonder over time, what does that mean if you've got, let's just say you're using SAP and you're training SAP's LLM to give you your AI outputs that you need to, make decisions or to run your business. And every other competitor in your industry, or a bunch of other competitors in your industry, are also using that same AI model. Does that just sort of water down your competitive advantage now? And who's the real winner here? Is the winner you, the customer, or is the winner going to be SAP in this case, or the software vendor, because now they've got all this data and this mass, really cool, well-trained AI model, which is great for SAP, but is that great for you as a customer now? You've just sort of like given up your core competitive advantage potentially.
Yeah, no, I think you're right on with that analysis. And I think for me, the way that I would view this is, I think the winner in that scenario is the software vendor. They're getting all this information, the data, the processes. They're understanding how their customers operate. And one of the things that we have been seeing, I would say, really in the last 2 years, and certainly more now, is when we are negotiating these contracts, these vendors are trying to very much put a fence around the data that you have incorporated into or input into their system. And so if you remember, about 5 years ago, maybe it's a little bit longer than that, there was this whole indirect use concept associated with SAP, where if you had another piece of hardware or another piece of software that was actually interfacing and pulling data from the SAP system, that would count as a user, and it would count against your license metric, and there would be fees that would be due to SAP for that. And they very much want to do that with your data. And so, if you're going to put that data into, we'll just use SAP as an example, into SAP, you have to make sure you understand what fees are they going to try to generate from your utilization of your own data to train third-party artificial intelligence software. Okay, because this is a repository of all your data anyway, I would assume, right?
Yeah.
And so now they're trying to extract additional money for you to be able to utilize that data to do other things with it outside of that SAP ecosystem. And where's the value add for that? I don't know, but it's certainly going to be expensive. And you got to look at that contract very carefully to make sure that you understand their ability to charge fees for that and the fee structure that's going to be utilized to extract additional fees from you.
No wonder the vendors love AI so much.
Yeah.
all the stuff you're saying is like, well, yeah, no wonder they're investing so much money in AI, because they're making a good amount back on that.
I think, yeah, definitely. I mean, you look at this, and I look at a lot of this AI stuff as kind of a shiny object, right? It's a lot of sizzle. Maybe it's not a lot of stake right now. It's hard to tell, but everybody's trying to sell you artificial intelligence. And okay, well, what can you really do with it in some ways? I mean, it's some of the things you can do that are incredibly amazing. I mean, if you look at hyper automation, what is it, robotic automation process? I can't remember the
RPA, the
the-
robotic process.
yeah, robotic process automation. You know, I mean, these things are amazing, right? And you're taking everyday tasks that you do on a regular basis, and now you're automating it at a huge high level. I mean, certainly that's an incredible thing to be able to do. But in some context, I mean, AI is okay. Well, where's the value add for it, really? It's not always there. But
Yeah.
for the vendor, it is, right? They're getting all your data.
Yeah. Yeah. And maybe this is why, or this could be part of why. I don't know if you saw it, but we had Jan Bond was on this show just a couple weeks ago, and he's the one that founded Bond Software, which is a big ERP provider back in the 80s and 90s. They were a prominent ERP vendor, and now he started another company, more of a microservices composable ERP sort of tool set. Anyway, he was on the show, and he was adamant about how your AI should never be within the ERP system. The ERP system should just be basically the transaction of record, and then you want to layer on top of that an AI model that you own, you control, not the vendor. And there's something to be said for that. I thought he had a pretty compelling argument, because you do think about, well, if data is a really important asset to me as an organization, and I want to be able to make decisions better than my competitors, why would I just give all that up, to a big software vendor who now makes that commercially available to every other competitor and non-competitor out there?
I could not agree more. I mean, I think you're ceding control over one of your most valuable assets to a third party that's going to then charge you to be able to utilize it in a way that you want to, right?
Yeah.
And one of the core tenets I go by when I'm reviewing, negotiating these contracts, is to get as much flexibility as I can for my client in the way that they're going to utilize this software. So it's either a license, like a traditional on-prem license, it's an access to a cloud solution, but the goal is to get all the indicia of ownership within the constraints of that contractual framework, so that you don't have to pay additional fees for utilizing the software in ways that make sense for you. And it's even more true with your data. I mean, you don't want to give up ownership of your data, which you aren't necessarily giving up ownership of it, but you're giving up flexibility, and you're subjecting yourself to fees for the use of something that is yours.
Right.
I mean, it doesn't make any sense.
Yeah, it doesn't make any sense. But when you're a big ERP vendor, and you have that sort of control and lock in of customers and that sort of thing, I guess you can do those sorts of things because you can.
Absolutely right. I mean, you're kind of at the mercy of these ERP vendors. They're the only game in town.
Right. Here's a really interesting question, kind of related to that. And I had never thought of this question before, but I think it's a brilliant question. This is from Emerson on YouTube. Emerson says, will independent AI organizations also develop parasitic relationships that also provide lock-in across verticals and horizontals? So in other words, if we do what we're saying, or what Jan Bond would suggest, or what it sounds like you might be suggesting too, if we say we're going to use a separate AI tool set to sort of bolt on to our existing technology stack, whatever that is, will that AI vendor then just become the next big ERP vendor to now get us locked in and hard to get out of? What are your thoughts there if you had to predict the future?
I would be pessimistic, and I would say absolutely that's what they're going to want to do, right? Because that's where the fee generation is. If they've got a lock on your data, and they can make a reasonable argument that there's some value add that you need to pay for in order to utilize that data with a third party product, they're gonna find a way to get that money from you. And I think that's a great way to say it. It's a parasitic relationship, right? And Jan Bond is absolutely right. Like, why on earth would you put all of the sensitive data into your ERP system and give up maybe not ownership of it, but control over it.
Yeah. Yeah. Now, what about kind of coming back to the point you were making earlier around training AI models? Um, I know this is asking you to give sort of a legal recommendation when you don't have all the facts, which I know is something that drives attorneys crazy. But just in generally speaking, would you advise to embed and reserve rights to train AI on anonymized data in the contracts, or give away to opt out? How do you negotiate that piece of it?
Well, I mean, I think if it's going to be, data is a broad word, right? But certainly if it's going to be personally identifiable information that you have an obligation to protect in connection with data security laws and regulations, then you're most likely going to want to utilize best practices and anonymize that data to the extent that you can. I mean, can it be de-anonymized? Probably, but you've got to put contractual framework or restrictions around that vendor's ability to do that. But I think certainly to get the value out of that AI functionality, you're going to have to give something up, right? And I think putting anonymized data is probably the way to go, because at least it's going to allow you to assert that you've complied with your data security obligations. And I mean, maybe you're giving up less control of that data. I don't know.
Right. Right. Yeah. Very, very interesting. And a couple different angles I hadn't thought of before here as it relates to this. Are there any other anything else we haven't talked about as it relates to AI adoption and some of the legal risks associated with it? Is there anything else kind of low hanging fruit we should be aware of when we're negotiating these contracts?
Yeah, I mean, I think there's just a ton, and it's hard. It's such a broad question. Um, you know, I think you've really got to be concerned with, just as a general tenet when you're talking about artificial intelligence. It's data security. What happens to your data? Are you disclosing inadvertently proprietary information, confidential information, trade secret information that you can't get back, right? What are implications for intellectual property infringement and intellectual property protection? You talked about it's kind of watering down and making a level playing field for everybody, but if you're trying to protect the output that you're getting from utilizing your data in this AI functionality, if it can't be copyrighted, how are you going to protect it, right? I mean, what competitive advantage are you actually getting from it, and how are you able to exploit that and capitalize on it versus your competitors? Everything they're now having the same information, right? You have to have some level of transparency about what is that vendor doing from a guarding aspect with respect to your data and your information. You have to have an understanding of how that algorithm might work. You want to understand bias issues. You can't have an over reliance on the AI functionality in general. I mean, you've got to have some human involved in that process in some way, shape, or form to be able to just double check to make sure that this is accurate. And certainly from an intellectual property perspective, if you're trying to protect anything, you're going to want to have substantive involvement from a real person, that's making decisions about, how to incorporate, how to select, and how to modify.
Yeah. Yeah. Very interesting. What about the cross-border data transfers? So if I'm a multinational organization or if I'm a domestic organization, do I need to worry about where the data goes?
You do, and I think you've got to really have some understanding of the geographical reach of how you're going to utilize that information, right? So I think where are you getting it from? So I mean, if you're a global company, which affiliates, which subsidiaries, which offices are you collecting information from? Okay, because each one of those jurisdictions is going to treat data security or data security obligations, privacy issues associated with it. They're all going to be treated slightly differently. There's going to be some overlap, certainly, and I think the default for a long time has been, if I comply with the strict regulations of GDPR, I'm going to be generally okay. And I think there's some value to that, but you still have to have an understanding of, what geographic regions are you collecting from? Where do these people live? What laws are they subjected to? And it's not even just with respect to foreign countries. I mean, okay, so you're gathering information from the EU, but what about China? What kind of personally identifiable information regulations are currently in place, in whatever jurisdiction that you're dealing with? California, EU, okay, well, those are kind of, well settled, but, there are new state laws coming online all the time, right? And that's not just with data protection, it's also with artificial intelligence, I
Yeah.
mean, you've got, don't hold me to this, but I think it's about a third of the states have enacted some sort of, comprehensive data privacy law. Okay. And if you're operating in those states or between those states, you're going to have a pretty good understanding of what your legal requirements are. And there is going to oftentimes be some sort of a representation or warranty in that agreement that you're going to comply with those laws. I mean, you have that obligation anyway, right? But you have to do the due diligence to understand, where you're sending this data, how it's being sent, who owns the data, or who has rights to that data. And it's not always easy sometimes, especially if you're a multinational corporation with multiple different offices in different countries.
You're making me wonder if any or if many organizations out there that are in the process of negotiating ERP contracts or any sort of enterprise technology contract right now, presumably it involves AI, because so many of these products have embedded AI, and these data privacy laws continue to evolve. I wonder how many organizations have actually thought through the stuff that you just talked about. I mean, because I feel like it's not top of mind for a lot of organizations. I feel like a lot of organizations just sort of march forward, sign the contract without really realizing what this all means long term.
I think the sophisticated ones are getting there. I mean, and you've got to understand. I mean, when we started our conversation, you've got companies that are signing agreements without actually fully reviewing all the contracts that are referenced in those contracts, right? I mean, they're signing an order form that has about 70 pages of terms and conditions that nobody looked at. Those people are just asking for a lawsuit, basically, right?
Yeah.
But I think the more sophisticated companies that have a reasonable due diligence process in the evaluation and the selection of the software are actually thinking about this. Not as much as they should. I think they're looking at it from, okay, where are we having distribution centers, right? Where are we going to be utilizing the software? They're not so much looking at it from, hey, we've got a subsidiary in Canada, we've got an affiliate in Mexico, and all that information is coming into the United States. They're not really thinking about it that way. They're thinking about it in a collateral way. Where do we have warehouses? Where do we have distribution centers? Where are we located? And what kind of what kind of impact does it have on the fees that we're going to be paying that vendor, right? And then I think they start thinking about their data security obligations in those different jurisdictions.
Yeah.
But still not substantively.
What about so we've talked about the sort of the contractual vendor facing side of some of these contractual and intellectual property data privacy sorts of issues. What about though as it relates to our employees? Let's just set aside the vendor facing side of things and just talk about our own employees internally. What should we be thinking about when it comes to data privacy? What happens to data in these AI models? Is there, are you seeing any sort of impact on the employment expectations or the employer expectations in that relationship to protect data, to have guardrails around how AI is or isn't allowed to be used within the organization? How are you seeing that unfold?
It's a little bit of a different scenario, and I think from a data protection standpoint, your obligations are your obligations, right? And whether it's a customer or an employee, if you've got personally identifiable information that is subject to data security regulations or laws, you've got to comply with those obligations. And it's not really going to matter so much if it is an employee or a customer. I think from a broader perspective, as you're looking at the employees and their utilization of artificial intelligence, I mean, I think you have to make sure that you have some sort of an AI policy in place, and that dictates what they can and can't do with artificial intelligence functionality. Whether they're pulling it off the internet and utilizing publicly available, sources, or if it's proprietary and it's embedded within the ERP system. I mean, do you actually need to utilize it, right? And what are you need to have a review of what your business processes are, how they can be enhanced by artificial intelligence, and then have some sort of policy in place that puts some guardrails around, what is acceptable use associated with artificial intelligence. And you don't want people putting in sensitive information into some sort of publicly available artificial intelligence functionality that they've got off the internet, right? I mean, there's significant liability associated with that, and they should only be able to use approved pieces of functionality, AI products, and only for a defined set of uses. And the company should dictate what that is and enforce it.
Right. And set those those operating procedures and get those in place so that employee handbooks, all that stuff I would imagine needs to be updated with.
Absolutely. And that's, everybody needs to have that right now. And that's, we just did an acceptable use policy with respect to artificial intelligence for a hedge fund. And, there were certain things that their employees could use AI for, and there's certain things they can't. And, the dilemma, I think, for an employer is, especially employers that want to embrace technology and view it as a cutting edge differentiator in their marketplace from their competitors, is how do you promote the use of artificial intelligence and not restrict it too much, right? You've got to limit your liability, but you still want to promote innovation, efficiency, and the utilization of this kind of technology. But there's got to be some sort of a balance, because you've got to limit your liability with respect to it. So, I think what was it? Was it Walker
Reynolds?
Walker Reynolds, right? I think he was at a conference, your conference, and I was listening to his talk, and I think he said that every one of his employees has ChatGPT up, and on one screen while they're doing their work. There's value to that, certainly, but there's tremendous amount of risk, right? If you're not monitoring what they're doing, you're asking for trouble.
Yeah, especially if you're dealing with confidential information, or if you're a consultant, and you're working with a client and you're using their information. What liability are you exposing them to? What liability are you exposing yourself to? I mean, there's so many people touching your data that might also be touching AI.
Exactly. Right.
First, to see where that goes, what some of the implications are longer term with that trend.
Right. And I mean, you've now introduced your client's data into a large language model that's being utilized to train their competitors, and the introduction of that data can be traced back to you, and it was proprietary or confidential. You've got significant liability right now.
Yeah. Now, what about given all this? Well, before I ask you this other question, I'll ask you a different one. If a company does find itself in some sort of legal dispute with the ERP or AI vendor, what immediate steps should they take? And we haven't really talked about legal disputes yet, but let's assume that something happens with these contracts, something gets sideways, they didn't negotiate something right up front, or your vendor doesn't deliver as promised the way they said they would, or you think they should have. You find yourself in sort of a potential legal dispute. What do you recommend as a first step there?
Yeah, I mean, well, the absolute first step is preserve all your data. Okay, all the communications. You want to put a hold on deleting anything that's related to that project, that implementation, and make sure that you preserved it so that you can utilize it later. All right, and that could be anything from text messages to recordings of Zoom meetings, Teams meetings, whatever you're utilizing. But all that needs to be preserved. And then the second thing I think you really need to do is you have to have a cost benefit analysis. I mean, is this project savable? Okay. Can you salvage this? Have you lost all confidence in this vendor's ability to do what they said they were going to do? Right. And, as I always say, that, these things don't fail. You don't get into legal trouble normally because the software doesn't work. It's the implementation and integration of that software that causes the problem. And, you know, have you lost all faith? Can you turn this thing around? And if the answer to that question is you can turn it around, we still have some level of trust in this vendor. I think you're going to want to do everything you can to get that project right-sided and avoid a legal dispute. And the reality of this is you spend 20, $30 million or more on an SAP Oracle system, or whatever vendor it is, and you sue them, they're not going to take that lightly. They are going to push back hard. This is serious litigation. They're going to have huge law firms on the other side. It's not something that you do lightly. You're going to be focused on depositions. You're going to be, going to court hearings. You're going to be spending a tremendous amount of money in legal fees. And I think the legal fees that you can expect to spend, if you're having a real substantive dispute that goes very, very far in the legal process, up to trial or even a trial, I mean, it's not going to be cheap, and it's not something you're going to want to do, and the outcomes are almost always uncertain. So, I think, think about it very carefully, and if you can resolve this on a basis that keeps you out of, a lawyer's office, that's the way to go.
Yeah, and of course, a lot of this all begins with where we began this conversation, as far as negotiating the right contracts, making sure you're all on the same page and have a clear understanding of the assumptions behind the agreement and the T's and C's of what's in the agreements you're signing with the vendors. It all sort of starts there. So if we sort of back up even more and say, let's assume we all want to avoid litigation. We don't want to let it get to that point. What can or should we be doing early on, when we first start a project like this, or we first start the procurement cycle with the software vendor? What should we be doing from a negotiation perspective? Because you've given us a lot of good advice, good takeaways here. But how do we get started on that journey if we know we're about to engage with a software vendor?
Well, I mean, I think it starts at the selection phase, right? And you have to have an understanding of the business processes that you need to improve. An understanding of where you're at today and where you want to be at after you've implemented the software, right? That is key to understanding, the value you're going to get out of it. You have to go into this thing with realistic expectations. You have to know that it's going to take a long time. It's going to cost, much more than you think it's going to cost. It's going to be more complicated. And you have to take everything that vendor says with a grain of salt. You can't trust them, unfortunately. I mean, when they say, look, this is an out-of-the-box solution that is designed for your industry, it contains industry best practices, that's probably not true, okay? And they're saying that to minimize the complexity of that implementation project, to get you to sign on the bottom line. And you've got to go into this thing asking the right questions, doing the proper due diligence. You've got to, conduct site visits, software demos. You've got to be able to know how to utilize all of those tools to your advantage, because the cards are stacked against you, right? And you can do all this stuff and still end up in a problem. And then once you start negotiating contracts, you really, I think the most important document that you're going to negotiate is the two. One is the MSA, okay? And the second one is going to be that individual statement of work or statements of work that govern the project. And those have to be detailed and specific. They've got to have meaningful deadlines. They've got to have meaningful milestones, acceptance testing. All of these things have to be spelled out with a lot of specificity. The challenge that you have with negotiating those is that I think most statements of work are really a snapshot in time, right? They're done at the beginning of the project. And while there's going to be, or there should be, some mechanism for utilizing change orders as that project changes over time, you can't manage via change order. And I think you've got to look at the project plan, have some insight into how that works, work with the vendor on that project plan, be involved in the process and incorporated by reference as part of the contract. And ideally, any representations that were made to you get you to get into that contract should be incorporated by reference as well as either warranty obligations or some contractual obligation, so that it's all all buttoned up. And, it's not easy to do all that. Vendors don't want to.
Right.
You got to give yourself a dog in the fight. And
Yeah.
the contractual process is the mechanism by which I think you can do that.
Yeah, and it would protect you from having to hire you as someone to help litigate or defend in a lawsuit versus just hiring someone like you to get it all buttoned up front.
Right. Absolutely. I mean, spend the money up front because you're going to spend a lot more money on the back end. The goal with negotiating these contracts is to be able to put them in a desk drawer, pull that out 2 years, 3 years into the implementation when something isn't going right. Look at, clause 5, section 1B and say, okay, well, we anticipated this. And when this happens, we're supposed to do this and you're supposed to do that. Ideally, there's going to be some contractual framework for resolving that issue, and detailing whose obligations are whose. That's what you want, right? You don't want some generic form agreement that everybody signs that doesn't help you at all.
Yeah. I love that in a couple of your responses, including this last question I had just asked you, in the background, you could hear sirens, these ominous sirens, like fire trucks or whatever you could hear through your office there. It was very, did you plan it that way to, as you're talking about the risk, the legal risk, you could hear sirens in the background, which made me.
No, I wish I did. It's a nice soundtrack, to make you take these things seriously. Unfortunately, I'm in Chicago downtown. And so I don't even hear them anymore. So
yeah, you're just used to it. Yeah.
I'm just used to it. Yeah. Which is a good metaphor for these lawsuits. I mean, you're just used to dealing with this chaos, and that's what you need, right? You need somebody that's objective, that's not going to be intimidated by the vendor, that's not going to be susceptible to, the vendor false sense of urgency associated with getting a deal closed by the end of the month, the end of the quarter, the end of the year, the threat that all these discounts are going to disappear. You need somebody that can stand up and guide you through this process. And it's not just lawyers that do that. It's also people like you. It's, the software selection consultants, people that are going to negotiate the business terms specifically, that you can hire people like that. There's a team of professionals that you can utilize and you should utilize if the deal size is big enough.
Yeah. Well, you've established yourself as quite the thought leader in this space for people that maybe they're not quite ready to reach out to you, have a direct conversation yet. How could they follow you on? I know you've got a YouTube channel, LinkedIn. What are some of the best ways how can they find you in some of the content?
Yeah, I mean, you can find us on our socials. It's Marcus Harris Attorney or Software Attorney, Marcus Harris Software Attorney. If you put Marcus Harris in, you're going to get an NFL player, which unfortunately my NFL playing career is probably not going to happen anymore. Probably a little late for me, though I had big dreams at one point.
You still have time.
We always have time, right? Your MBA career is probably in the not in the rear view mirror, but in front of you as well. And
being 5'9", I'm a perfect prototypical NBA player.
It could be a shooting guard, maybe, I don't know, or
Exactly.
point guard. But yeah, Marcus Harris Software Attorney is going to get you to our YouTube channel, our LinkedIn. It's going to get you to TikTok and Instagram and Twitter, Blue Sky. I mean, it's we're virtually everywhere. So there's a lot of good content on our channels, long form videos, short form videos, and I invite you to, if you're not ready to have a live conversation, I mean, take advantage of that. It's a good resource, and it walks through a lot of these things in more detail, in a way that I hope is easy to understand and digestible.
Yeah, I was just going to say those exact words. The content you put out is, well, first of all, I'll say you're the only attorney I enjoy listening to. And I mean that there's no other attorney I want to listen to, which I don't know if that's a compliment to you or an indictment on your profession, but
it's a little bit of both, I think. Yeah.
Right. I'm kidding, but I do actually I really like your content because you make it so easy for the lay person to understand. It's not, as smart as you are with the legalese, obviously you have a way of sort of dumbing it down for people like me that don't understand legal stuff. So I do recommend you follow your TikTok channel. Your YouTube channel is really good too. You put a lot of effort into that, especially recently. Good. Well, yeah, be sure to follow Marcus, and thanks for being here, Marcus. This is a great conversation. Really appreciate your insights as always.
I appreciate the invitation and look forward to doing it again in the future. Thank you.
Absolutely. As fast as this stuff is changing, it seems like we have to have you on like every quarter or something like that just to keep up with what in the world is going on here in the enterprise tech space.
I agree. I mean, it's the vendors are changing their tactics, certainly, yearly, and the contracts change too. I mean, the contract that we negotiated with a vendor last year is going to be different this year. So
Yeah.
it's fast moving right now.
Absolutely. Well, good. Well, thank you for your time. Really appreciate it. And thank you to the audience for the great questions as well. I appreciate everyone chiming in here today. And again, we'll take this interview, we'll edit it, add some additional content. It'll become part of the Transformation Ground Control podcast episode that comes out 2 weeks from tomorrow. Every Wednesday, we have new episodes that are released. So be sure to check out transformationgroundcontrol.com and you'll see this interview with Marcus here in a couple of weeks. And in the meantime, there's 200 plus episodes you can go watch or skim through and see which episodes appeal to you. But you can find all of that at transformationgroundcontrol.com. We do the same live interviews, same time, same place every week. So wherever you're watching from here today, you can join us at the same time every week. So different guests, different topics, all related to sort of the tech agnostic objective view of digital transformations. Thank you all for being here. Have a great week.